Hello, everybody. Welcome to this week's Matrexit discussion group call. And let's start out this evening here, just displaying the 17 USC subsection 107 disclaimer for copyright, because we're going to be showing some things tonight, some pieces of things, which is strictly for educational entertainment purposes. And we've got our friend with us here this evening, Jeramy Baker. And I know most of you on here are not familiar with him. This is the first time I believe that he has been on here with us. We've been here for about 4 years, something like that. And the past few weeks, I've been doing this series, basically entitled Rabbit Holes. They're really rabbit traps. Because when people start getting into whether you want to call it the truth movement or whatever the case may be, we end up finding all of these little detours, all these rabbit holes. Here, people talk about it. It's like, you're hit with such a plethora of information. It's like, what do I do? You know what I mean? It seems overwhelming at first. That's why I was as well. And I decided that the smartest thing to do would be just to take one of them at a time. And this was the first one I tackled here probably 5, maybe 6 years ago. And it really wasn't too hard to figure out. And I actually have an article I will be posting on YouTube in the description box regarding a Supreme Court decision talking about right to travel. Because that's what we're going to be going over a little bit this evening is right to travel and some of the different attempts that people make at other various rabbit holes, I guess you call them. So let's stay with that. And some of them can be quite entertaining. And I really think that a lot of stuff is thrown our direction just to dissuade us, or get us off in the wrong direction, especially if you're fighting some sort of a legal court battle. And social media really isn't going to be the place where you're going to be finding very much useful or truthful information. A lot of it's going to be things that are just going to cause the judicial administrator probably to chuckle, or maybe even ask for some sort of a psych evaluation for you. Which I know a lot of the videos I've seen, if I was a judicial administrator, I would definitely be wanting a psych eval on some of these people. Because you can tell that stuff they've learned is just very, very confused on there. So anyway, let's welcome Jeremy Baker on with us this evening. How are you doing, brother?
I'm doing pretty good, man. Thanks for having me on your show and let me speak today. It's very awesome. Thank you for the hospitality.
Absolutely. You want to fill people in on who you are and how you got started in this, I don't know, this big rabbit hole we found ourselves in, trying to figure out what the truth really is.
Right. Well, I remember kind of where I started. I had a mentor that was kind of showing me a kind of different strategy and I see it on the internet sold a lot now, but they're arguing about that they're not a person, and then they'll come in and they'll argue that, and that they'll argue the argument of artificial persons, and then they'll argue the argument of natural persons, and they're not wrong. It's just that the fact is they need to understand how to make the arguments and how to put them in a form that makes them have to hear it. The thing is most of these people are struggling with trying to be able to explain it to the court. And that's the biggest issue. So everyone's got like a different angle and everyone's trying to cause confusion. I mean, I ain't going to get.
I think we just lost you for a second there, Jeremy. Just about the different angles and stuff, especially regarding that word person. Everybody wants to run from that. One of the things I find frustrating, Jeremy, people bring up the Bible verse, God is no respecter of persons. And it's like, good Lord, people, that was written in Greek or Hebrew. The word person wasn't even used. Come on.
Right. Well, the thing that I was looking at with the person's argument is the aspect of where they're hitting you with. And sometimes you could write the brief However, the aspect of how the court's going to react to you is what you're looking for, and you're trying to be persuasive, and you're trying to get your the desired outcome. And I would say the best way to approach them from the experience that I've learned is to articulate your arguments well and to stand on your arguments strong. And you got to understand how to sell your arguments. And if you're any good at sales, you could be good in that field. But the thing is it's a lot of it's cryptic. They won't teach you.
Yeah. Yeah, it is. And I've noticed judges or court administrators will throw hints to people, but people just have their heads so full of what they want to say and everything like that, or they don't ignore it, or they just don't hear it. I'm not sure what the case is, but it's kind of frustrating to observe some of these different court cases. Because I get lots of them sent to me. They're like, Brian, listen to this. What do you think?
Yeah, they gotta understand how to be receptive with the judge and answer, not give the speech. You know what I mean? And it seems like that's what people are missing.
Yeah, especially
treat them like a person.
Yeah, especially people getting the first appearance, and most judges, you're hearing them today starting right out saying, "Listen, I don't want to hear anything about the case. This isn't that," because that's not what that specific meeting is for.
Exactly.
It's just your arraignment.
Exactly. And that's where the whole aspect of comprehension of where you're at and what you're doing and what you're talking about. And it's always one topic at a time. That's why I was trying to implement Robert's Rules of Order kind of and letting people understand that when we were doing our class a little bit and making it so people can kind of get understanding of it, making it so people will stay on one topic. I mean, because you watch people just run around and you can't ever get anything done. It's the same thing with people running around in the court because they'll come in and they'll have one rabbit hole and then they get cornered and they go to another one and another one and another one, or they'll just give up after a while. You can see how people will struggle, but it's weird whenever people get wins and they didn't really have to fight for it because the prosecutor showed mercy, and then that person goes out in the world and thinks they're like the next coming of Moses or something. It's pretty scary.
Yeah, the whole the judge bows to sovereign video.
Yeah, I mean, people probably went turbo with that one after they saw that, because if you were being receptive to what happened, he's leaving the courtroom. He just went turbo. So, did they ever tell you the results and all that? I would say that from some of the best people that I've learned from and the things that I've seen, they're always trying to use their arguments in a fashion where they take the substance of the topic. And I was talking to this one guy that had been doing court cases for like 60 years, and he told me the simple thing that he learned from, if you want to beat every court case, is to go right through it. Just grab a hold of the topic and dismantle it right away. And now, if you can do that, then you'll be able to win your case. But if you can't do that, they're going to always bring it back up. And they're going to always beat you on that topic if you can't settle that topic. So from what I'm seeing now is using logic and reasoning with your rule and your case law. It's almost, it just makes sense. What are they going to do?
Yeah, it's funny. I had somebody contact me and they said, "Hey, Brian, somebody told me not to listen to you because they think you're an attorney. You sound like a lawyer." And he told him, and said, "Wait a minute, you mean because he uses logic and tries to figure it out situation?"
Right. I mean, it's really what you're just doing. I mean, you're just trying to be receptive with the court. You're just asking them requests. You're trying to treat them as people so you can get the desired result. If you get an argument with the judge, you're basically not putting yourself on any type of good ground at all. I mean, in any sport, where would you go argue with the referee?
Exactly.
You're not going to win your case that way. You've got to be able to actually beat your opponent and then have him say, "Yeah, you beat him."
Well, Jeremy, I think you had a entertaining video or two you wanted to share with us.
Yeah, I got a couple here. I got one that is talking about this guy. He doesn't really understand his topics, but I think what I should do first to make that more funny is to actually kind of give you an understanding of Robert's Rules of Order, because parliamentary procedure is what's going on in the court. Okay. And I've learned this from experience. This is not something like I've been taught, but the aspect of it is how I've interacted in the court. And I've got some understanding of how things work, because I've got a little bit of experience in this realm. But what I understand is it's all about one topic at a time. So this is the video that this guy breaks down Robert's Rules of Order. He's going to give you 7 rules. And then after that, I want to show you the other videos and watch what's going on, because this guy's going to give you the breakdown on how to talk to people in a public manner. So here we go.
In 1985, 11-year-old Edwin Tay sat in the back of his 5th grade social studies classroom, hoping that the teacher wouldn't notice him and call on him to speak. I was shy. The other kids in the class were more outgoing, more talkative, and naturally they raised their hands more often and participated. They quickly became the teacher's favorites, and oftentimes they would dominate the class discussion. I observed how the more these kids raised their hands to participate, the more confident they seemed to get. And at the same time, I also observed how the more I noticed how confident they got, the less confident I seemed to get. It was almost as if confidence was like a pie. And the more slices of confidence they took away, there were less remaining for other people like me. Unfortunately, class participation was always a part of the grade. I would always seem to score low in that area in all my classes. This pattern developed and continued throughout my educational career. Many times I tried to break this pattern, but there would always be so much inertia. And the longer I waited to start raising my hand, the harder it seemed to get. Until one day I just stopped trying. And I sat silently in my classes, feeling invisible, like an outsider. After college, I breathed a sigh of relief. No more class discussion, no more class participation, it's over. However, I quickly found myself sitting in the middle of staff meetings, company meetings, and I'd be hoping that the supervisor or the meeting facilitator wouldn't notice me and call on me to speak. Same pattern again. I disliked, I was uncomfortable, and I avoided meetings. And then I realized that it had become a serious handicap. And I desperately wanted to break this pattern. I didn't know how, I didn't know where to go, I didn't know where to start. Later on, there would be a man who would help me break this pattern. No, I didn't see a shrink. I didn't see a therapist. In fact, I never even met this man, but he would help me break this pattern. So who is this man? In 1863, 26-year-old Henry Roberts was an Army engineer stationed in Massachusetts, assigned to safeguard harbor defenses. One day, he found himself unexpectedly called upon to facilitate a town meeting of private citizens at a local Baptist church. Despite having no training, no prior experience with how to run a meeting before, he decided to jump right in and give it a shot. He had faith that the assembly would behave itself and maintain order. After the meeting, he was completely embarrassed, completely humiliated. And he vowed never again would he step foot into another meeting until he learned something about parliamentary procedure. Newspaper accounts at the time indicated that the meeting that he ran lasted 14 hours and accomplished nothing. He was so personally humiliated by this experience that he went on a mission. He went on a mission to learn all he could about parliamentary procedure. For those of you who are not familiar with the term, parliamentary procedure is the term for the standards and the rules for how to run a meeting. So Henry Robert rummaged through all the existing manuals and materials he could find on parliamentary procedure, but nothing he found was comprehensive. Later on, he started observing the United States Congress and how they ran their meetings. As a starting point, he adapted their rules, and where there were situations where there were no rules written for, he started making them up according to what he thought made sense. Decades later, Henry Robert had created, compiled, and refined his rules of order. His rules of order were published, it spread like wildfire, and organizations of all types throughout the country benefited tremendously from his rules of order. And the purpose of his rules of order were to assist an assembly to accomplish the work it was designed for in the best possible manner. The rules are simple and are as follows. 1, only one matter may be addressed at a time. 2, only one person may speak at a time. 3, nobody may speak for a second time until all who wish to have spoken for the first time. 4, everybody in attendance has a right to understand any question being raised at any time and also to understand the impact of their decision. 5, everybody's vote counts. 6, the majority vote decides the issue. And number 7, the rights of the minority are protected at all times.
Okay, so that's basically the court in a nutshell, and that's the arena. Those are the rules, and that's also public speaking. And then you've got, this is an example. This guy is he's doing some public speaking, and it's clear he doesn't know Robert's Rules of Order, but you know, he wanted somebody to record him while he went up there. So here's the video that he got.
Next speaker is David Thompson. Talk about Homeland Security. David Thompson. Yes, welcome, David.
I stood up here last time, Thompson. I'm going to ask back a little bit if when I get into this, if you can give me an extra minute or 30 seconds. And once I get into this, I can see why. And
with everybody. I apologize.
I'm here tonight to request John Walsh of the FBI's Most Wanted to make public and request America's number one public enemy. We have a rogue helicopter pilot on the loose inside this airspace. He's also on the loose inside this country. And I am after this report right here, which is a classified document from the Freedom of Information Act within the FAA. When I came down here to speak back in April about the bundling, I went home. I said something because I had to back it up, because I went to the Smith Junior High meeting years ago and I reminded you of 4 things I said, which was no smoking, 30,000 seats, solar hot water panels on it, and put ice in the arena. And I told you why there's no ice in the arena. I made a statement, and the statement was the reason there's no ice in the arena is because somebody had their hand in the pie. He didn't want ice in that arena because he knew down the road, just like with the NBA, eventually the NFL and the NHL were going to expand. And if you allowed ice to be put in that arena, that means sometime down the road he'd have a competing tenant, which would lessen his bargaining power at the city of Charlotte. I've been ready to explode like Mount St. Helens since the weekend of May 27th and 28th. And what happened to me was the evening of the 28th, I woke up in my house at late in the evening, early mornings a.m., and my house was shaking. And it's shaking. And it kept shaking. And it shaked and it shaked for over a minute to 2 minutes. It shook constantly. And it was the same white helicopter that I saw on Sunday afternoon that flew over my house when I walked from my part of the house to my garage. The exact same. I won't raise my voice.
Boy Scouts in the audience, and they may be getting scared because
that's fine. They have a right to be scared because that's why I'm here tonight. I was scared. I was endangered, and I was threatened. My life was in danger because we have a helicopter pilot that flew 25 to 30 feet off my roof line between the magnolia tree and the property line for 1 to 2 minutes, and then he bailed out. And I followed him. And I've tracked him down through the FAA because I made an official report. Sue Myrick knows about this. The FBI knows about this. John Edwards knows about this. This Criminal Intelligence Division, the Charlotte-Mecklenburg Police Department knows about this. I want this pilot. It's a matter of national security. Wherever you are, Mr. Helicopter Pilot, come out of your hole. And you too, George Shin, because you were in that helicopter, Pop. You were in that helicopter, and you were nothing but a chameleon, lemon-headed, coward, terrorist pussy. And I'm after you, buddy. You're going to pay for it. Good night.
Thank you very much.
Yeah, that really happened. Yeah. So, and then you've got this stuff where people are just going extra turbo. And this is what they're saying to cops. I mean, this is not the reason. This is not the place to start arguing.
Articles of Confederation, you can look it up. It's in the United States Book of Codes. It is your laws you have to follow.
All right, I will do that. Well, watch back here.
Article 4, free inhabitant, pursuant to the Articles of Confederation.
Get the camera down for me. Is that if it records, that's fine. But I don't want you holding anything.
No weapons, no weapons. All right, no.
Okay, so what I'm going to ask you to do is the same thing.
To get out of the car?
Yes.
No, I'm not getting out of the car.
Okay.
You can go get your superior.
Well, I am going to tow this car, and you cannot be in the vehicle while I'm towing this vehicle.
Well, if you go get your superior,
That's not
he'll
gonna happen
clarify that he can be set free because he does not have
It's
to
not
have a
going to
license.
happen right now, young lady. So either you're going to come out of the car on your own free will, or I'm going to assist you.
I'm going to get out of the car and walk down to that house.
No, you are not free to leave right now.
Are you saying you have authority over me?
Yes, I do.
You have proven authority over me.
Yes, I do.
How did you do that?
I just don't understand why she's arguing with the cop in this situation. I mean, you get more with honey than you do vinegar. And then I got another example here. 1 second.
Well, the situation also is that this isn't even her matter. Whoever it was the operator of that vehicle. It's their deal to have to fix, not anything to do with her, and it definitely has nothing to do with Articles of Confederation.
Yeah, I mean, she's just arguing so. I mean, she's making herself look bad. I mean, I heard that you can make yourself look smarter by looking or by staying silent. You know what I mean, and just dealing with the situation.
Yeah, that's what Mark Twain said, Samuel Clemens. He said that you're better to remain silent and be thought of as a fool than to open your mouth and remove all doubt.
And that's a fact. I mean, because it's just best to just ruin yourself and listen to what's going on in these situations. I mean, it's scary sometimes. And then you got this guy right here, and you wanted to do this video, right, where the guy's trying to play, where the judge hammers him.
Yeah, this is a video that I have on my created playlist called Sovereign Citizens and Truthers Seen as Clowns. I've got about 20 videos on there, and I thought it was funny in class when you showed that previous video, because I think I've got that video on the same playlist.
Well, it's kind of sad when you're watching some people trying to interact in parliamentary procedures and they just don't understand what they're doing. And they're trying to make it complicated for them, and then they'll make it complicated back, especially if they are good at arguing. And some people just aren't good at arguing, so they'll be a one argument wonder, and then they'll get destroyed, and then they just don't know what to do after that. And I mean, granted, fact that they had courage in the very beginning is very encouraging. I would encourage people to, read the rules and stuff like that. I mean, learn what you've got for discovery. Figure out what's going on there. You've got like 29 or something like different pre-trial motions you could file before trial. And then people are arguing about stuff that's just not even necessary.
Yeah, things that don't make sense, things that are these rabbit holes that I was talking about. And it's stuff that just makes you, look like a complete idiot. And you're talking about being able to articulate your issue. Well, one of the first things that you can notice when someone is unable to articulate the situation is a raised voice. They start yelling and screaming because, yep. And then after that also will come the ad hominem attacks, right?
Exactly. Well, they got all kinds of different ways to, stop you from what you're trying to do or whatever. And the aspect of it is they also might play dumb, and that happens. But here, let's go ahead and start the video and show an example of this real quick.
David Hall. Next, we go to a bond hearing in Broward County. Judge John Hurley presiding. The defendant is David Hall, a sovereign citizen who basically believes that certain laws don't apply to him.
Mr. Hall has declined the services of the public defender, Your Honor.
Hall is here for driving under the influence and driving with a suspended license.
Mr. Hall, DUI, expired driver's license.
Judge.
As soon as the judge attempts to read the charges, Hall begins interrupting.
Sir, I haven't said for the court how I'm appearing today, sir.
I'm not asking you yet. Just give me a moment, all right? I need to look at your record.
Turns out Hall is currently out on bond for 2 previous charges of driving with a suspended license. But that's not going to stop him from trying to make his case.
Sir, today I'm appearing as the agent and settler for David Hall.
Okay. Could you get Mr. Hall for me then, sir? Where is he?
I go by that name, sir. My name's...
Now, this is the person argument that we were just talking about. So it's kind of interesting how this plays out.
Sounds exactly like the defendants, and I'm here to settle that matter today.
So are you and David Hall one and the same person?
I'm not a person, I'm an individual. David Hall is a person. I am a private individual.
Hall's legalese is unconventional, to say the least, but the judge allows him to continue.
May I say something else for the record, sir?
Go ahead, sir.
I appear here today as the settler, agent, not the person, but the individual. And I don't think I should have you understand the difference between a person and an individual.
Agent, and you're the individual, but you're not the person.
Now you just made it 15 times more complex. I mean, you see how he changed like multiple topics right there?
Yep. He's a chief cook and bottle washer and isn't really sure who he is. All right, Jeremy, I think we dropped you, or you were dropped.
That's correct.
Correct.
I'm going to write that down.
Judge Hurley is unfazed by Hall's attempt at a Jedi mind trick and begins to turn the tables.
Here's what we're going to do. The settler, the agent, the individual, and maybe even the person, David Hall, has been charged with DUI. So today, the court's going to set the settler, the agent, the individual's bond, and even the person's bond today at $10,000 because the settler, the agent, the individual, and the person get a driver's license.
Hall's new bond is $10,000, but because this charge is a violation of his original bond, all versions of David Hall must remain in jail unless he can come up with the cash.
Both cases will cause the settler, the agent, the individual, and even the person, David Hall, not to be able to be released from the Broward County Jail until further notice of the court. So,
may I post bond, sir?
Now it's Judge Hurley's turn to have some fun.
Well,
is there any other?
Are you asking me as the settler, the agent, the individual, or are you asking me as the person?
Sir, I'm asking as the individual appearing before you today, the opportunity.
Speaking on behalf of right now.
He clearly just, now he's in the boa constrictor argument. Anything he says now is just completely, he's done. He's just going to get swallowed. So it's awesome. Here it is.
Sir, I don't understand that question. I believe that you're trying to confuse me now. I'm not the person, sir.
Okay,
I am not
the person, David Hall. Tell him he's not leaving jail either, all right? Have a nice day. Thank you.
Thank you, sir.
I mean, that could have went so much better for him.
Yeah, absolutely. And another version of this video also, there's a part of it where David Hall stops the judge and says, "Hold on." He says, he uses a driving argument. He says, "You're saying I was driving. I was not driving. I was traveling." And the judge said, "Okay, I'll agree with that." So the judge went back and restated the charges that he was traveling without a license.
Right. I mean, really, it gets down to this, the nitty gritty. They've got to understand that what they're fighting is words. It's all chess with words. And if you're going to argue anything, just make sure that you got to understand how to IRAC. And IRAC is the issue, rule, application, conclusion. There's other formulas like CRAC is conclusion, rule, application, conclusion. And then there's, if you don't have a law, but you want to argue reason, you can always use an IAC. And an IAC is always an interesting way of doing it to make it so you can form your arguments. But the aspect of it is to bring forward your arguments in a way for them to understand them so they can rule in your favor or rule against you. But if you go and you make it right, it's going to be real hard because you can appeal it all the way up to the Supreme Court. And if you use all their binding case law from the state, I mean, that you're in, it makes it real fun.
Well, and here's something, Jeremy, too, that I find really interesting, and I've mentioned this the past couple of weeks, and that is that one of the issues that the state is finding themselves in, and I, in a way, almost would feel sorry for some of these judges, because since these people have not been educated on how the system works, they're not educated, for instance, on Robert's Rules of Order and that type of thing, then they don't know how to conduct themselves while they're there in court. And it's making things extremely frustrating for the whole proceeding.
Absolutely.
And it here probably about a month ago, a friend of mine introduced me to a girl he was seeing, and she was currently in college down there. I think she's going like to Southwest Florida. And I asked her, "Oh, well, what are you taking? What courses are you majoring in?" She says, "Well, I'm really just going to college to become a paralegal." And I thought, "Oh, that's interesting." I said, "Where are you at in your classes? Are they teaching you how to, for instance, like you mentioned, IRAC?" I asked her, "Are they teaching you how to IRAC a case?" And she had no idea whatsoever what I was talking about. So this whole educational system, it isn't even just a problem with the novice on the street, but even a lot of the people within the system aren't fully informed on how procedurally everything works, or even how to research or IRAC a case. I found that kind of fascinating.
Yeah. I mean, they give you so many different examples. I mean, you could literally go in. I mean, let me see what I can do.
Do you have something else there that you're pulling up?
Yeah, I got a couple things I can show examples on. I can actually kind of show a couple of different ways of doing things here. One second. I wanted to show you something. So what you can do is you can go in and you can take like just a regular, say you want, what you've got to do is if you're trying to IRAC and you really want to learn how to do that, really you just go into some case law wherever you want, where you're at. Say you want to go to, let's go to Texas there. All right. So you go into Texas. Wait, let me show you. Okay. So I'm going to share my screen again.
And I recommend to people also, if you are involved with something, whatever particular court you're involved with, each court, the judges will have their own rules and things they follow as well. And that can be very beneficial for people to learn about.
Yeah.
And put that in your quiver.
It really does. It really does help. So you go. I usually go to state materials. I go to Westlaw, and then I mean, granted, you have to pay for this application, and it's actually a pretty awesome engine. But you can go in here and you can say, Texas is kind of fun because they got all kinds of really cool laws there, because it seems like the legislature almost seems like they care about their people a little bit. Granted, you still got a lot of corruption there, but some of the laws, man. Here, let me show you in a second. Texas Code of okay, so we go in here. I usually go into a case and then I'll hit actually the area where it's at, and code, and then there's places for all kinds of things in the rules, of course, but you want to find the criminal rules.
Now, I'm not sure what it's showing on your end, Jeremy. On my end, it's showing that you're buffering and you're having a Wi-Fi issue, but your audio is fine. I mean, I am hearing you totally fine.
Oh, okay. I was just trying to pull up a screen shot of this video real quick. I mean, if I could, if it doesn't pop up, I don't know what to say. But the aspect of what I was trying to show was on Westlaw. When you get to the thing, you get all these other states that you can go check out, and you can find out what the rules are or whatever you're looking at. And they do have sections like the code of criminal procedure, and they usually have it for each state. Well, what you want to do when you're trying to IRAC issues is you're just trying to make sure to find a topic to talk about to be able to IRAC on, and that's really all it is. So let me show. I can show an example here. I'm trying to find one where it's a motion to set aside a indictment. Where is this at here?
And one of the important things as well, yeah, you're talking about going through Texas code. The reason why you'd be going through the Texas information is because that is a case that is in Texas. And you see so many people that are showing different cases that, number one, it's not only is it not in their state, but it is a totally different judicial district. So the courts are not going to be necessarily compelled by that. You want something at least within your district, if not the state.
Yeah, it's exactly a fact, because the thing is that that's the rules that they have, and they usually reflect the federal rules. If you'll notice, if you get a little bit of practice in there, you'll notice that it does reflect the federal rules, but they'll make a little bit different, or they'll go put a little bit of different pizzazz on it, or call it something else, but it'll always be the same thing. Okay, so I'm looking up a motion to set aside an indictment, and just so you can give a top, you can talk about. I mean, just so I can show an example of this Texas code.
Yeah, for some reason it's still not wanting to show anything on your side.
Okay, well, I can turn my screen off, I guess, in 1 second here. I'll try it again here. All right, so here we go. Boom. Boom.
And a lot of this stuff might seem a little bit monotonous as well, and it can be, especially when you're researching a case or whatever. Like I said, in the notes, I'm going to put the one I did on the Supreme Court says you don't need a driver's license. And I started going through some of those cases. I did a handful of them today, and it is a pain in the butt to shepherdize a case. But when you dig in and really look, you're going to find they're talking about something that is not quite exactly as it's being presented. All right, you're on there now. Good, Jeremy.
Okay, perfect. Okay, so there's this rule in Texas, right? It's called motion to set aside an indictment. All right, so what you do is you go in here and you try to find out one of the elements for them to dismiss the case, right? Well, it says under here, under Texas code, right? And it goes down to here, and this is the issue that I'm trying to point out. That says, or that the information was not based on a valid complaint. Now, boom, there you go. Now, that's when you come into this. Can you see this?
Yep.
You can see my screen?
Yep.
Okay. And okay, so no, this Word document, 1 second.
Because then when you see something was not a valid complaint, then that means, okay, you got to dig a little deeper. What constitutes a valid complaint?
Yeah, well, that makes it even more interesting. Okay, so here we go, and I've got you. Okay, so this is what's going on. You have this issue here where people are making invalid complaints because they don't really know what's going on. So, and they're not lawyers because, honestly, a lot of these people aren't that are doing this.
Can you expand that screen at all?
Can I expand this screen? Yeah, I can do that. Boom. All right. Now, in the aspect of where I would start is I would break down the rules. So what I want to do is if I'm going to make an argument on this, well, that would be cool. But in Texas, they kind of banned you being able to get the grand juries, right? So the only thing that you've got here is this, okay? So it's not based on a valid complaint. So that's my issue, okay? So I'll come in and then I'll say, all right, well, I want to have this be my issue. And so then I'll have to make a fact pattern. And then this is really what it comes into. And this is really just the tell your story spot. Tell your story. And that's it. And you go in, and that's the facts or the statement of facts is what they call it. Okay, so then you go from there, and usually if you're going to write a motion and you really want to do it good so there's no confusion at all, you always want to put this at the very, very top. Relief sought, and then and then just kind of give them some words to explain what you're asking for, and that's kind of it. Now, say you're going in here and you're saying relief sought is motion, that this court dismisses this case with prejudice. I mean, you always want to put it. You always want to go the extra mile, if you can. And
Would you say with prejudice?
Yeah, with prejudice. You want to dismiss, of course, but you want to dismiss it with prejudice. Okay, so that's the relief you're seeking. All right, and then.
Okay, Jeremy. At this time, I think this would be good to explain to people the difference between with prejudice and without prejudice.
Okay, well, the aspect of with prejudice means they can't bring it up. Without prejudice means they can bring it up. So the thing is you would have to go argue the with prejudice part if you were to appeal it. So that would be an issue, all right, that you would have to go in and IRAC out, okay? But the thing is what you're just trying to do is try to get your case dismissed, and you don't want them to ever bring it up again. That's the language you want to use there is with prejudice, because what they did was prejudice your rights by what they did to you, and then try to explain what happened. Okay, and then you can really do some numbers here. I mean, you can start out with your statement of facts, and you can say, if you can articulate it well enough, you can make it sound good. And this is where you got your place to tell your story. So if you put your story down and it just so happens to meet the criteria of not having a valid complaint, and you show how and why. Okay. Now what you do after that is you want to show them what the statute is that you're being charged with. And then let's go and I'll find an example here. 1 second.
Yeah, okay. That's an important part. I mean, on your end and on their end is showing what is being used, because number one, something has to have been broken. A law has to be broken.
Yeah, so you want to go in and you want to see what the statute is that they have violated, just to make sure that you're on topic. You know what I mean? So you're not changing the topic at all. So let's say, what would we say a person gets charged for? Let's say DUI. Let's make this interesting.
And you've mentioned a couple of things also along the way here, Jeremy, that I kind of like to bring up, because these are rabbit holes that people come across. You brought up grand jury earlier, and I want to get into that a little bit later on. But you also just brought up the word statute, and you hear all these people go, statute is not law, da 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 da. Well, that may be correct, but statute is prima facie evidence of law. There's actually a document written on that that's out there that I have. But yeah, the statutes, people need to realize that is a snippet that's taken from a public law, something that has been written by the legislature.
Yeah, and the legislature is kind of where it all comes from. So you've got to do the aspect of where your arguments are coming from and what you're trying to enforce and all that kind of stuff. And the legislature puts forward laws where they say are crimes, and then that's what you've got. And then you have to be able to fight these type of cases, and people don't understand the approach. I would say that some of these cases can be fun if you do it right, but you've got to know the rules. I mean, if you're going to ever represent yourself in a court case, read the rules. There's no, I mean, that's one of the most important things you could ever do for yourself.
Yeah, and the rules are out there. They are able to be found. I mean, the rules are not, I mean, I was in court one time and I heard a guy say, oh, I don't need an attorney. I've watched Law and Order. Oh, I'm sorry. Law and Order are not the rules.
I mean, it's hilarious that people would even go there. I mean, it's kind of, it's sad too, but that's the reality we got. I remember one time I was quoting Bible verses to somebody in a conversation, and he started quoting movie verses. I was like, that's just so bad. It's like it's so out of the conversation. He doesn't even understand what we were talking about or how it would be presented. It was funny. Anyway, you've got this statute here, driving or actual control while under influence, right? So this is the statute that we're going to break down. So the statute itself is where the elements are. Now, you got to remember when you're writing these things out, the facts invoke the elements. So the first one is this one. So while under the influence of intoxicating liquor or any drug or vapor-releasing substance containing a toxic substance or any combination of liquor or drug or vapor-released substance, or this is their statute. Okay, so this is another one. And then you've got all of these elements here. Okay, so what you've got to look at is the elements and how they are invoked. Okay, so you look at the first one, and they're most likely is going to charge you with this statute. Okay, and this is the way they're going to present it. They're going to come in and they're going to say, you violated this statute right here. Okay, now there's a trick that I've learned. This has been a little while I've been doing this, but what you want to do is you want to understand what they're looking at here. Okay, they're saying intoxicating liquor, right? And then they say any drug, right? And then they say vapor releasing substance. And then they say any combination of liquor and drugs, right? Okay. Now, most of the time when you get charged, what you're going to see is they're going to say something like, going to see something like to that effect, right? And then you're going to say, they're going to put a date in there somewhere. But the problem is this, right?
Can you read that out for people that can't quite read that on the screen?
Yeah, what you've got here is in this statute, there's multiple different issues here, okay? Multiple different issues. And because there's multiple different issues, and they didn't put any facts there, it was all conclusory. Nothing's there. There's no substance. Where? Okay. And then they don't know how to write an affidavit, and then they're usually lying in it so they can get a freaking charge. So, I mean, you want to make sure to be as nice as possible, a police officer, so you can get as much information as possible. So the least you want to do, the worst thing you ever want to do is argue with the cop, period. Just don't ever do it. I mean, that's the worst place to have your arguments. And then also, always, you know, shut them down. Just say, hey, I got to have an attorney present. Or if you're getting pulled over, you know, what the other attorney said, what would you check me at? I mean, that really kind of makes them, that's their lingo. But the other aspect of it is you've got to be respectful to these people, and you've got to talk to them in a normal manner. So my aspect of it is there's intoxicating liquor, right? There's any drug. Okay, so you've got reaching. Okay, so my question is here is, which one is it? Okay, now there's a motion that you would do is lack of specificity, right? Or lack of particularity. And it's a simple motion to dismiss. So the thing is you would take your argument here, and there's a failure to state an offense argument is what you're trying to do, okay? So the law on failure to state offense, let me give you some case law on that so you can kind of see. I'll read it to everyone as well. There's a failure to state a claim is basically what they do to us whenever we're trying to sue them. And there's a case that's out. It's called Iqbal versus Twombly. Iqbal versus John Ashcroft. And then there's Twombly versus the railroad company. And these are two cases that have changed the legal system across the country. And those two cases have basically been cited in so many cases, it's not even funny to get cases dismissed. And you'll see it in the most serious cases that you've ever imagined. And the person that was, like I've seen situations where the person was absolutely guilty and they worked for government. And the fact that they did their immunity failure to state a claim argument, they were able to get out of it. And that sucks because a lot of people just can't express or articulate what happened. That's the problem. And if you can't put it on paper, that's how they're going to get you.
Yeah, that's the federal rule 12B6.
Yeah, 12B6 is failure to state a claim. However, if you go over to Rule 12 in the federal rules of the criminal procedure, there's a sister law, and it's called failure to state an offense. Okay. Now, failure to state an offense is a very powerful weapon, and it actually attacks the valid complaint issue. This is where you're attacking the complaint. And because people don't know this aspect of being able to attack the complaint correctly, it just doesn't get met. So what I've decided to do was to mess with, learning this strategy, learning this motion, trying to understand what's going on. And from what I understand, from after I've been doing this for a little while, the aspect of how you do this is more or less a science. And I'm trying to get this aspect. Where's the other one that I just had for the notes?
Yeah, it's like a science or a witch's brew to use in the county temple.
Well, in some respects, it's like it is a science. It's the aspect of being able to express what you're trying to say. And sometimes you can be really articulate and have fun with it. And it is fun. And that's what I like about it, is the aspect that you can actually go in and actually have a different type of battle, because you know how to express yourself. You know how to explain what you're trying to say. So it'll make it easier for you, but because you know all your facts, right? So let me find a couple cases on failure to state an offense here.
Yeah, I think this was one of the situations that my mom and dad had an issue with me growing up because they would ask me to mow the lawn. I'd say, sure, yeah, I'll mow the lawn. and and come the end of the day, they're like, you didn't mow the lawn. I said, yeah, I know. You said you would. I said, no. I said, I will. I said, I'm very aware. Yes, I know I said I would. And yes, I will. And I think they would think about it like overnight. And the next day they would say to me, okay, Brian, are you going to mow the lawn? And I said, yeah, I'll mow the lawn. And they'd say, good. Are you going to mow the lawn today? and they would catch me in that little word game. But I mean, there's just so many things that are word games. And it seems nowadays, even just having regular conversation with a lot of people, I get lost in their conversation because they are not able to articulate their thoughts, let
Yeah.
alone specificity in it.
Yeah, that's the thing. Okay, so here we go. Here is a case law.
And searching these things out, I reckon these things, yeah, it can be a little bit monotonous, as you see here. But
Yeah.
I mean, once you find the gold, you found the gold.
Yeah, it really does get it gets to be fun once you understand what you're doing. Okay, so I've got all these different types of instruction manuals. Like what we're seeing here. Do you see this right here?
Yeah, duplicity.
Yeah, duplicity. Okay, now duplicity is the topic here. Okay, now let's go ahead and read what it says. All right. Wait, let's go ahead and change that. All right, so duplicity is the charge of separate offenses in a single account. In a single count. So that means that you're being charged with separate different things in one count, right? Okay, now duplicity is a form of what? What law? It's a form of double jeopardy. Okay, so what you've got is you've got double jeopardy inside of it, and then what's it say? This practice is unacceptable because it prevents the jury, right? So all this language right here, and it goes. It prevents the jury from deciding guilt or innocence on each offense separately, and may make it difficult to determine whether the conviction rested on one of the offenses or both. Okay, so now let's go back to our document that we were looking at here. Now we've got duplicity. Now you understand what the issue is, and you're looking at it, and what do we got here? We've got duplicity inside the statute. You see that? So what you'll find is they failed to state a claim. They failed to state an offense because they didn't do it, or they didn't do it with particularity. So what you want to do is you want to come in here and you want to cut this, paste it here. So you want to flow your argument together. And then, so you're going to come in with the idea that
And it dropped your screen there again. But that somehow not really looked at in depth, but it makes total sense. You've got one charge, and underneath it, there's many things that are actually layered or stacking. That's what they call it, is stacking, and things that are stacked in there. And so you get found guilty on the one charge, but maybe two out of the three things that were listed underneath that charge, you didn't have any guilt of.
Yeah. Well, the other one that they like to do to you too is called multiplicity, right? Whoa, what happened there? Okay, so you got multiplicity, all right? Now, multiplicity is when they have an indictment where you're getting charged with several counts of the same offense. And that's what you'll see whenever a person gets charged with like the same crime over and over and over and over for the same thing that they actually, for the same exact type of crime.
So you're saying multiple charges for one action and not necessarily separate actions.
Yeah, I mean, this is it right here. Like, I mean, to see it in layman's terms, it would be like charging you once right here, and then charging you again right here, same crime, and then charging you again for the same crime, and then charging you again for the same crime. That's multiplicity, okay? When you're what I just showed you with this is duplicity. So that's really what I mean. That's the mentality that people need to understand when they're breaking down complaints. What am I looking at? You know what I mean? And that's really all it is you want to make sure you want to define what you're looking at, and you want to understand how to approach it. And if you don't understand any of this stuff, it's just gonna rock your world, and you're not going to be trained.
This is probably one of the things that you see when you see somebody getting charged, for instance, with 13 counts, right? And then when it comes right down to it and they end up being found guilty, they're only found guilty of like 2 different charges instead of the full 13. As they go through those 13, there might be, like you said, multiplicity in there, and it might be several statutes that relate to the crime, but they're throwing them in there to see which one will stick.
Yeah, usually what you'll notice is if they've got a really weak case, they'll do multiplicity on you. And it's just because they've got to do something, you know what I mean? So they just want to see what can go on there. But it's actually a form of, if you want to get into it here, let me show you what's going on. Okay, so you've got this multiplicity issue. And you've got to understand what's going on here, because there's a thing that's duplicity, or multiplicity and duplicity are both of double jeopardy issues. And they're putting you in a double jeopardy situation where they can go and accuse you of multiple different things at one time, just so they can get a conviction. But it's actually putting you in a place where you could, but the thing is they're trying to do it for, spaghetti or traction. But the fact is it's completely illegal. A lot of the other states have actually said that if you are charging them for this, like a person got charged for first-degree murder, and then he had a charge for second-degree murder, and then they said that he couldn't have that on the same indictment. That's ridiculous. Okay, so now we get to the subject that I was talking about, is failure to state an offense, okay? So this is the pleading or defect in the failure of the charge of the offense, all right? So then you have all this different case law that's down here, but it's talking about it up here, how it's cited. Okay, so a motion to quash or demur, and these are basically defects in the indictment, all right? So now the federal Rule 12 is usually how you're going to do this. You're going to do it with a rule to make your objections, because you're trying to actually get somewhere and actually have the court preserve your objections. And you have to do that by bringing the stuff up before trial. Okay, so failure to state an offense. Now, failure to state offense is going to be probably whatever rule it is for Texas. Probably, I don't know, there's going to be something for objections. If there is, they probably ain't going to tell you what it is, okay? You have to go to school to figure it out. That's kind of how they do this. Anyway, but failure to charge an offense would be how you attack the valid complaint. Come in here and you can do this one, failure to state offense on duplicity, or you can do it on this one. But the aspect of failure to state offense in itself is they didn't meet the elements of the charge. So if you're going to be charged with this, they're going to be a little bit more specific. You know what I'm saying? Okay, so this one is duplicity and then lack of particularity. Okay, now that's actually a motion. If most people don't know that, but it actually is something that you can do is motion to dismiss for lack of particularity, and that's because what they wrote down isn't reasonable. It doesn't. You can't even read it and understand because it doesn't have any applicable facts. See, the thing is, they like to win their cases based on failure to state a claim. I mean, there's cases that you'll find across the country where horrible things have happened, and people have brought lawsuits up in the name of their families and tried to sue, and then they would get a failure to state a claim argument on them. So the aspect of it is you can do the same thing with the failure to state an offense if you're good enough, but you've really got to understand what you're looking at.
All right. When we started out, we're talking about the whole driving or traveling issue. And I think one of the things people need to realize as well is that just because the federal government says one thing doesn't mean that a state can't say something else as well.
Yeah, that's true.
So you got to figure out, whose rules are being applied. I mean, that's the number one thing to figure out, because you're not going to be able to go into necessarily looking at the multiplicity or duplicity situations if you're not first comprehending, what playing field they're on. You know what I mean? If it's a state situation, you can't be going and using federal stuff, or vice versa as well.
Yeah, absolutely. Well, that's why it's so important to understand the topics, understand what you're writing on, understand what how you're going to approach them. Make sure that you're listening to respond instead of trying to argue. A lot of people don't understand that either.
Yeah, and people just really need to comprehend how all the moving parts operate. That's far from, like I mentioned, whatever you're going to see on Law and Order. It's very, very different from any of that. And like with the driving issue as well, Jeremy, I mentioned to you earlier this week, and I've tried to explain it to people this way: is that there's that one article out there from wearechange.org that says, the United States Supreme Court has said that you don't need a driver's license, to travel, or whatever they titled it. And the cases that they listed in that article, none of them I shepherdized even related to that issue, hardly at all. Some of them, zero. One of the cases they cited was a situation just where people were holding a protest. It had nothing to do about using a vehicle. And I've tried to explain it to people like this as well, as that even if SCOTUS, even if the Supreme Court of the United States had said that, no, you don't need a driver's license, insurance, registration, yada, 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 then guess what? Fine. That's what they're saying at the federal level. But when it comes down to the states can say, yeah, you've got the right to travel, but we're going to put these caveats on it, just like they do with environmental laws. The feds can say, sure, standard, you're allowed to go and drill for oil. Okay, good. But that doesn't mean they've got an open hand to do it what they want, wherever they want. Once they go down, for instance, to Texas or Louisiana and they want to drill, the state can say, sure, yeah, you have the right to drill according to the federal law, but here in our land, you've got to follow, you've got to use certain type of pipes, you've got to follow these laws and these rules and these procedures in our state. But yeah, you still have the right to drill, you still have the right to travel, but we're going to put some restrictions on it.
Yeah. I mean, well, the thing is we've got all these things where we want to argue and all that, and unless you want to have like 1,000 lawyers following you around, and you've got to have the money for that to pay for all your stuff, it's just no reason to go and try to pick fights with people when you have your Pampers on. That's just the way I look at it. Just try to learn the game first before you start to go and try to beat them at it.
Yeah, absolutely. First, learn the game. And like you said, you're going to need a legal team. You know what I mean? You got to decide your battles, and justice costs money. So it all kind of comes down to how much justice can you afford. You know what I mean? Now, this doesn't mean that there's not a way out, that there's not another avenue you can take when it comes to maybe the whole driving and traveling issue. But that's a totally separate matter. There are things you can do, but a lot of these rabbit holes that you're being taught on all these various topics online, what they're feeding you is nonsense.
Yeah, because they're giving you false hope, and then you're going in there, and then you're damaging yourself. I mean, why would you want to do that? I mean, it doesn't make any sense to just go and sabotage yourself. So why would you do it? If you don't know what you're talking about, what are you doing?
Well, and it would be nice if they were just giving you false hope, but a lot of these people are charging you for it. They're charging you for it, and then they disappear.
Yeah, it's a really dark game out there, and because they just don't understand. You can always see, you can find who the charlatan is when they don't have any substance to what they're trying to show you or anything. I mean, that's why I always like to ask them questions and show me a court case you won, stuff like that, just to see where they're at. But no, for real, in the aspect of this, they went in and they made this argument right here where they said John Doe was driving while under the influence, and then they didn't explain which one it was. Okay, so what we've got here is we've got what? 70 of these bad boys? So he's made 7 different charges inside of one just by quoting the statute alone. Okay, so then you're like, I got you, bro. You just totally hooked me up. So you go over here and you look at duplicity. And then because of that, you have the argument that you want to make on duplicity. You also have, if he was to charge you multiple things, you would have multiplicity. But the thing is you've got 2 issues here. So that means you could make 2 different motions. Okay. So you can make a motion on duplicity, right? And then you can go over and you can make an argument also on failure to state an offense. And that one is right here on the valid complaint. So I'm just want to give you a couple of different options is what I'm trying to show you here.
Yeah,
so
excellent.
So lack of specifics. Okay, so
I had a situation a few years ago, Jeremy, where I had been given a ticket for failure to obey a traffic signal. Now, since I failed to obey a traffic signal, what do you think it was that I actually did, Jeremy?
I have no idea what happened. You just turned. What happened?
There's a lot of different kind of traffic signals out there, isn't there?
Oh yeah, of course there is.
And I went into the clerk and said, "Hey, the only thing on here, it says failure to obey a traffic signal, and I can't think of what traffic signals there even are in that area where I was pulled over." I said, from the direction that I was traveling from, if it's, say, for instance, a traffic light, like a red light, there hadn't been a red light probably for 4 or 5 miles behind me.
Yeah.
So what kind of traffic signal did I fail to obey here? I'm not comprehending this. And actually, the clerk herself ended up tearing up that ticket.
That's hilarious. Yeah, that right there has to do with that issue right there. And it's the same thing. It's failure to state an offense. So it's an indictment or information must contain all elements of the offense. Lack of specificity. So they've got to actually, with sufficient description of the acts he's alleged to have committed, so he can adequately, or so he'll be able to enable him to defend himself. So this right here is so important, and it's a killer in the court, but people don't know about it. Just shuts them down. All you got to do is say, hey, this is my story. The statute, which drug was I on here? They're like, all of them. Yeah, that doesn't work.
Yeah, you're having quite a party, weren't you?
It's like all in yourself or something. I don't know. It's like, which one was it there, guy? He was like, you know which one? He's like, no, I don't. Can you explain it to me? Which one? And then he doesn't even know. He can't even say it. Because a lot of this stuff, like they'll just lie. And I mean, I'm not saying that they all will. Some are actually, we've got some good guys out there, but at the same time, we've got a lot of bad guys too. And people just don't want to believe they exist or something. I don't know. Well, from what I understand is in any business and any trade that you're going to find in this world, most people are going to try to learn how to cut corners. You're going to find a shyster in some area. You know what I mean? In any profession that you get into. How can people say that that's not happening in our government?
Exactly. And, I've told people before as well that when you've got to go, say, for instance, even into the DMV for something, people all think, oh, this is government. Well, number one, no, the DMV really isn't government. There's so many of these offices that have all just been farmed out, and agencies that have just been farmed out, that they're just instrumentalities. They're not really government. But people get so nervous and afraid and scared when they go in there to do different things. They need to realize that those people sitting behind the desk are no different than the rest of the Americans out there. That they want to get to work as late as possible, do as little as possible while they're there, and also leave as early as possible. And during that time, they're thinking about if they've got clothes in the washer that they got to throw in the dryer when they get home, and do I need to stop and pick up something for dinner? They've got all the same mindset as everybody else. So we shouldn't be in fear when you're going in front of these people. You need to realize you're just dealing with another man or woman just like you are.
That's exactly a fact. And that's where you're going to get your best possible result too, is whenever you actually go and speak to them like they're people, and they'll treat you the same way. But make sure to read your rules and make sure to try to articulate your emotions well. But the aspect of it is it's all about just treat them the way you want to be treated, and then most time you'll find that they'll treat you the same way back.
Yeah, and here's so many people say, oh, the whole thing's just a racket, it's a game. Okay, sure, it's a racket. Sure, it's a game. Look at it that way if you want. But if it's a racket or a game, rackets and games all have rules to them. So learn the rules.
Yeah, I mean, Robert's Rules of Order is not that hard for basic public speaking. That's one set of rules. Then you're going to have to understand what the rules are in order to be able to interact with that court to be able to get the desired result. If you don't understand what the rules are, you're beat before you started. That's how important it is. I've seen it many times where people will come in, they won't know what the rules are, they have everything in their favor, and they still lose. And that's because they waived all their objections. They didn't understand what they were doing. They didn't file the right motion. They didn't argue the right stuff. They totally overlooked all of this stuff. Duplicity, multiplicity, failure to state an offense. It's just crazy. And all of these are ways out, and it all comes from due process, man. Your rights of due process are so amazing, it's not even funny. I mean, you can literally defend yourself, and you can do it properly, and it's actually fun if you know how to do it. But just you've got to take the time to learn.
Absolutely. Well, Jeremy, I want to thank you for your time here this evening. And I think you've given some excellent hints for people. They need to pay attention to some of the details of whatever situation they're in, because it's easy to overlook your remedy when it can be sitting right there looking you in the face.
Absolutely. And let me break down IRAC for them real quick. Issue, rule, application, conclusion. So you're going to do, what's the issue? Well, we've got multiplicity, right? What's the rule on multiplicity? Well, according to Rule 12, you're allowed to move to dismiss the case on that one. Oh, okay. And then always, always, always remember this. If you're going to IRAC something, go find the holding from the higher court and the way they interpreted the rule, because the fact is they don't care about your interpretation of the rule. They care about the way they interpret it because the holdings are in place. And then you want to make an analysis of the facts based on that rule. And if they are similar to what you're looking for, that's what you're looking for to basically get your conclusion and the desired result. So you have to make sure that you IRAC your stuff correctly by pulling your case law, make it all relevant and all material to your subject matter, and then you can draw, logical conclusions. You can also paint a story. You can make it a little bit theatrical. But the thing is you want to draw a conclusion, because why? You want to get the judge to sign it. It's never about arguing with him.
Yep. And too many people just want to argue. There's too many people out there that enjoy the fight. And I think when I first started researching these things and looking into different actions people were taking, one of the first big rabbit holes you fall down is, I would say, the Patriot rabbit hole. And you see so many of these Patriot arguments being made, and these people, they fight them for 20, 30, 40 years. They fight them for their whole life. And some of them may even end up dying in prison or alongside the road or in a snowbank. And is it worth taking that road? To me, no, it wasn't. I wanted to be a little bit smarter about it.
Yeah, I mean, what do they say? They always say ignorance is bliss, but it sure is expensive.
Yeah, it is. I worked for an old Englishman one time, and he used to say, he said, ignorance is bliss, but some people abuse it.
Yeah, no, that's a fact. It's scary to see some of these people. I mean, can I play one more video, or are we wrapping up sometime soon? I can play another video real quick if you want.
No, go for it. Show us what you got.
Okay, I got a couple things. This stuff scares me, and I just want to show it to you guys real quick. One of. Okay, here we go.
Hillary's primary campaign promises is to help expand the Sharia law program in minority communities in America. Do you think that's the right campaign platform to be running on?
No brains. You see this? She is okay. Watch. She doesn't even know he's talking. She has no idea what he's talking about.
Yeah.
The Sharia law expansion.
Yes, I'd say yes.
To change the way women are treated in America.
Absolutely.
Okay, he just basically asked her, "Do you think it would be okay for them to stone you in the street for if you ever said anything bad about Muhammad?" And she's like, "Yeah, no problem, whatever."
Absolutely.
Sharia law.
Absolutely.
Hillary knows what's best.
Hillary's cool.
Okay.
I'm going for it.
I like your tattoo.
Thank you.
It's so sad.
Thank you.
Appreciate it.
Do you think Hillary's plan for the Sharia law is the right thing? Is it the right time for that in America?
I don't think it'd be a bad thing.
Can't be a bad thing.
Yeah.
Her Sharia law plan.
Okay, thanks.
Okay, thank you. One of Hillary Clinton's primary platforms is to spread Sharia law within the minority communities. You think that's the right thing to do in the New World Order?
I guess so. Yeah.
Would you support Hillary Clinton's Sharia law program? Do you think that's the right thing for the New World Order?
Sure. Yeah, I would.
Okay.
All right.
Checking. Thank you. Hillary Clinton, obviously running for president, could potentially be the first female president in the United States. Part of her campaign promises to implement the Sharia law program in the minority communities and in the middle class. You think she's on the right track?
Sure.
You're going to be voting for Hillary?
Sure.
Do you think that's the right way to take America forward, is to implement Hillary Clinton's Sharia law expansion?
Yeah, I do.
So you support your Hillary supporter, obviously?
Kind of.
Hillary, being involved in politics for several decades, has decided that expanding Sharia law in the United States is the best way to help
move America forward. You think that's the right idea?
I don't know exactly what Sharia law is, so I can't really
It sounds like it's a step in the right direction, but I don't know entirely. I don't know exactly
Hillary
what Sharia
probably
law
does.
is.
If Hillary has decided that expanding Sharia law is one of her primary campaign platforms, you think that's probably the right thing to do?
Sure. Yeah.
Expanding the Sharia law in America?
Sure, why not? Yeah.
Okay. All right, thank you.
Thanks.
Well, Hillary Clinton, obviously a big advocate for equality and helping to eliminate sexism. Part of that platform is to spread Sharia law in the United States, particularly in some of the urban communities. Do you think that's a good platform for Hillary to be running on?
I mean, if that's her only sole campaign strategy point, I think there's multiple strategies that you have to go for. Yeah, but I mean, I think that's a very good one to bring to the front. Whether you base your platform on that or not, I think you have to have diversity in what you offer to.
She's got a couple things. That's one of the, her triangular strategy.
Okay, so that scares me just based on the fact that these guys are just like completely out of it. Okay, they don't even have an answer. They have no idea, and that's scary because ignorance is not bliss there. I mean, if it comes out and plays out, they're not going to have fun at all. But here's another really good example of ignorance that we're dealing with in the country right now.
Had stricter gun control laws, that Lee Harvey Oswald would not have been able to shoot Jesus, or would he have still used a gun on the black market?
You still would have used a gun?
He still would have been able to get a gun to shoot Jesus?
Yeah, absolutely.
Do you think if we had stricter gun control laws that Jesus would have not been killed?
I don't know. It all depends. If someone wants a gun, they're going to get it and use it.
But I mean, if there were stricter gun control laws, would Lee Harvey Oswald have gotten the gun that killed Jesus? You think? Or you think that would have prevented him shooting Jesus?
I don't know. I really don't know.
Would that have stopped Lee Harvey Oswald from shooting him, you think? Because he would have needed a background check to get the gun?
No, I don't think I would have. I think people find ways to get around things.
It would have been on the black market. He would have got a black market gun to shoot Jesus?
Probably.
If we had stricter gun control laws, do you think that Lee Harvey Oswald would not have been able to turn Jesus over to the Romans at gunpoint?
No, because a criminal's going to always find a way to do what he wants to do.
So he would have still got a gun on the black market to hold Jesus up at gunpoint, turn him over to the Romans?
Because criminals will always find a way to do what they have to do to survive.
What year did Jesus die, approximately?
I couldn't tell you.
Just roughly. 1500, 1200s?
1300s.
1300s? What year, approximately, did Jesus die?
I have no idea.
Was it like the 1200s, 1300s? Just roughly. No help. This is only you. Just roughly. What year did Jesus die, approximately?
I have no idea.
You could guess.
1300s.
1300s. What year, approximately, did Jesus die? No help. No help.
Jeez, I don't know.
Roughly. I mean, was it like the 1300s, 1700s?
I'd say 13 or 12 or 13. Yeah, I have no idea.
Just roughly, if you could guess.
Nah, thank you.
No idea?
I don't
Just
know.
guess.
Oh,
No help.
Yeah.
Just approximately what year did he die? Just guess if you don't know.
Something BC or I don't know. That was a long time ago.
Was it in the 1700s?
1600s.
1600s.
Right? Like
Okay, 500 BC? AD? BC? 500 AD or 500 BC? Which is?
Well, die. I'm going to go AD since he died in after death. I don't know.
500 AD.
AD.
I don't know what year,
Just
approximately.
roughly, I mean, was it like the 1100s, 1300s? What year roughly did Jesus die?
Bad with dates, so I'm not gonna throw a date out there.
That's really what we're dealing with.
Oh boy. And he brought up a word with one of the girls that really was what was on my mind. Is like the word vote. Guess what? These are the people you've got out there voting. Why do you think the founders decided we needed an electoral college to make the decision on the presidency?
Oh yeah, big time. It scares me whenever you start looking at people, what they're thinking, and how they don't. They like refuse to. It's all about amusement. They just want to have fun, and just live in the moment. They don't understand what's going on around them. They don't see their countries under attack by other countries by coming in through the aspect of learning our stuff and then taking things over from the inside. They don't see any of that. I mean, how long has it been since Europe has basically infiltrated our courts, took it over and made it all barristers and all that kind of stuff? We've been running esquires in the courts for a long time, and people don't know about title and nobility. They don't know about any of this stuff. So the aspect of it is just letting it all get away with it. They don't even realize that they're dealing with foreign agent esquires, dealing with the queen, or dealing with the king now, I guess. And it's all in place. And they don't understand that this is commerce. But the thing is we've got to do it, and they're underneath their rules to be able to win. Granted, you want to see it and do it other ways, but the thing is what I mean, Albert Einstein said it. What did he say? You've got to learn the rules of the game and then play them better than everyone else. And I believe that.
You brought up something there, Jeremy. I want to touch on actually a couple of the rabbit holes. You brought up titles and nobility there, and people say that's why they got rid of it. I think it was 13th Amendment or whatever.
Yeah.
Was because it was a Titles and Nobility Act. When the Titles and Nobility is even still mentioned in Article 1, Section 1, Clause 10 of the Constitution. It's still right there. They didn't remove that part of it.
No.
So to me, that kind of does away with that whole argument that they made. But earlier you brought up the term grand jury. And it immediately made me think of all of these state assembly things going on all over the place.
Mm-hmm.
You want to address that?
Well, the grand jury thing, I mean, it's just a really touchy subject because it's all made it to where only the prosecutors can write the complaints and this in. I don't really know the topic of what you're asking me to talk about on aspect. I do know how to deal with grand juries, and I kind of see what's going on. And the problem that a lot of people are trying to go to the grand jury and bring evidence and stuff like that. And however, the rules are set up to where only the prosecutor can do that for you because they've got to write the complaint and they've got to write the indictment and stuff like that. But you also got to understand that they have a lot of control over the grand jury because a lot of people don't want to be there. So sometimes people do want to be there, but I don't know. In the aspect from what I'm understanding, there's safeguards that they put in place to where you can't do things to stop them from doing what they're doing. It's kind of weird, but if you're able to use and if you're able to understand their language and use their stuff against them, you'll be able to win. But the aspect of what you're trying to use against them is what your approach you have to take. You can either do professional code of conduct. You can look at official misconduct and lawsuits. The aspect of filing bar complaints or filing complaints with or doing civil arrests and stuff like that, a lot of people got to understand that they got to actually have seen the crime in front of them, and it has to be a felony in order for them to issue a civil arrest. And some people are doing that over misdemeanors.
Right. Yeah, and I agree. That 100%. That's one of the issues really with a grand jury is they're only seeing one side of the coin. There's nobody there to offer a counter opinion or anything like that. But what I was looking at, it started out actually as like state grand juries, and now it's morphed into state assemblies, and they think.
I think
yeah.
I see what you're talking about. Yeah, there's these people that are doing these citizen grand jury things, right? Is that what you're talking about?
Yeah, that's a big part.
That's hilarious. I mean, I always thought, where are you going to take them to? You know, that's funny. I mean, you're going to go do arrest, and then you're going to go and do an indictment, all this kind of stuff. The kidnapping charges on that are going to be horrifying. And
Oh my gosh.
And then all the people put them on there. I would say there's a better approach, and that approach would be to do it properly. I mean, you do have civil arrest statutes in your state, and if they did commit a felony, just make sure you articulate your facts out, explain what law they broke, and then kind of show your evidence. And if you do have evidence, you'll be able to. I mean, evidence comes down to two things: it's testimony and that which is tangible. So when you pull those two things together, and you make sure to make your argument in support of your complaint, you got them. But the thing about it is that you got to understand, whenever you're doing bar complaints, you can't just go hit them with a charge. You've got to show that the aspect of how you can get around their immunity. Yeah, and the only way that you can do that is by using the professional code of conduct.
Yep.
And then you got to invoke a law afterwards in which they violated, and now you got it. But the only funnel that you're going to be able to get through is to show that they violated the professional code of conduct. And it's really easy. Dishonesty is fun. So that's like all modeled throughout the country, 8.4, and you just go through 8.4 and look at the misconduct stuff. You can get it for sanctions. You can do all kinds of stuff. But the thing is learn how to write your own motions. Learn how to write them from scratch. And then when you ever get a form book or anything like that, you'll have fun.
Yeah, and it's in those canons as well. It's in their canons as far as the bar goes.
Yeah. Well, what I've noticed is I've been writing a lot of motions from scratch because that's how I was taught originally. But what I've noticed is whenever I get into some of these form books and I see some of the things that they're doing, this gives you different ideas on different formulas. You can always take different ways. Like you just want to see what they're doing, for an example. You're not really trying to take their stuff and say, oh, this is how I'm going to do it. But I do believe that there are people that do that.
Yeah, there definitely are. And if people, I hear people all the time ask about templates and stuff like that. There really is no template for any one thing, because everybody's case is going to be different. The particulars are all going to vary from one individual to another. So there's not one plain template, but you can go like to your great Oracle, go to Google and put in whatever it is you're looking for, whatever kind of form you're looking for, and then go to images, and it'll bring up pictures of other ones people have written, and so you can basically see how to construct it.
Yeah, I mean, getting an idea is a really good way to do it. There's also another way of doing it too. Here, let me give you this for example. There's a guy that studied philosophy, and he really did good. He got the highest scores that you could possibly. He aced philosophy, and he also aced the bar exam. And what he's on YouTube, and it's Insight LSAT, and he's got a little course there. And what he does is it's basically a prep course
across the world.
And what he does is he's basically shows you how to do logical reasoning and everything, and how to make your arguments and how to strategize making some of your arguments. I mean, he is fantastic, man. I was actually very impressed by him because the way he uses philosophy in his arguments and stuff like that, and the way that he shows you and the reason why you have to do it this way. That right there is so important. The reason why.
Yeah, I posted the LSAT YouTube channel in the Tactical Sovereignty Facebook group.
Nice. Okay, yeah. That video right there has a little package that you can go with it. You can actually study it and all that kind of stuff and try to understand what's going on and test yourself. You actually have a lot of fun doing that. And then by the time you get done, you'll know how to IRAC. You'll know how to IRAC like multiple situations. You'll know how to go in and out. And you'll know how to take the information that you're learning, put it on paper, and make it so they rule in your favor. And that's
Yep, and I'll have a link to the group also down in the description box here. But it's all important stuff to know. I mean, at first, a lot of his stuff seemed kind of remedial to me anyway. But as you get into it, you might start getting a headache.
Yeah, it gets overwhelming. You find yourself trying to learn a whole bunch of stuff that nobody will talk about or nobody will be interested in even learning, and stuff like that. There's another place that you can go if you do succeed going from there. Well, let me see 1 second.
And I want to say as well that a lot of people think that, if somebody wants to become an attorney, they just decide to go to law school. Well, you may want to go to a decent school, and you just don't become an attorney by getting into school and going to school for it. Number one, you got to get into the school, which is what that LSAT is for, because that's going to show them how you think and whether or not you would actually be skilled enough to go into that arena.
Yeah, absolutely. Absolutely. What I've got here is I've got this. There's a book. I guess if you go, it's not a book. If you go to Barrister's Books, I'm pretty sure if you look around, you might be able to find this guy. What's his name here? His name is Flemings. If you know anything about Flemings is like the guy that most of the really good writers that are in the legal world won't tell you about. And he's got a lot of stuff. Okay, so you get into his stuff and you'll find there's books like Fleming's essays, Fleming's examinations. They're all writing books, and he's got certain levels, and he's training you to pass the bar. I would say it would do you some good if you're just trying to learn this stuff, to go and grab one of these books and understand how the law applies to yourself, or how it applies to you, and how it applies to your situation and all that kind of stuff. Because one of the things that he expresses in his classes is if you don't know how to spot an issue, you don't know how to write on an issue. And today we just showed a couple issues, and some people probably have never even heard of them.
Bingo.
Yeah.
Well, I think that's a good tidbit to leave people with. Yeah, I know the name Flemings. I'm sure I've seen something from him, but I'll go and check him out as well a little bit more.
Oh, he'll blow your mind. One of the best writers that I ever met, he was telling me, I can get any motion granted that I want. And I was like, show me. And then he did. I was like, I like this guy.
Well, I guess we'll close this out. Like I always tell everybody, this Sunday, the first day of the week, not the 7th, not the Sabbath. And if you really want to start learning things, you first need to figure out who you really are, where you're from, and where you're really at, because that's where the deception's been. And a lot of this that Jeramy has put together this evening for us, thank him for it, because it goes directly to where we really are and what we need to be focused on. Thanks, Jeramy.
Thank you very much for having me on, and God bless all y'all for listening.
Good night, guys.